Namaste to you all. Good evening and welcome to you all. Hindu Council of Birmingham is proud to present to you all an insight of why it is important to have a will and have a lasting power of attorney in place. Tonight we have Jay Parmar, an associate partner at Paradigm and Legal Services, who will talk us through this important subject. Also note that this event has been recorded, so those who feel that they don't want to stay on because it's recorded, they can stay or they can leave. But further to do, I'll pass you over to Jay. Jay,
thank you, Vipul. Good evening, everybody. Namaste. And thank you to Hamir and Vipul for giving me this opportunity to be able to talk about wills and lasting powers of attorney, something really important. Now, what I'm going to just do is share my screen with you as I've prepared a short presentation to try and keep things a bit simple to make it quite easy to follow and understand. Feel free to make some notes and happy to answer any questions that you guys have after the presentation is finished. Okay, can you all see my presentation?
Yes.
Yeah, perfect. Okay. So my name is Jay Parmar. I'm an associate partner at a firm based in Leicester called Paradigm Wills and Legal Services. We are a STEP qualified firm and we support our clients with wills, will-based trust, lasting powers of attorney, probate and inheritance tax planning. Firstly, what I'd like to do is just give a bit of a background about our company, about services that we do, and then I'd like to then go into a bit about our wills and estate planning. So, bit about myself. This is my family, my wife Jyoti, my little boy Kian, and my eldest son Theron. And they're the main reason that I do what I do. They get me up in the morning, making sure I can make a better life for them. About Paradigm Wills and Legal Services, we've been established since 2015, and we became a limited company in 2017. We opened our probate department and employed our first staff member in 2018. Built our overseas presence in Dubai, USA and Portugal in 2019. By 2020, we have 13 staff excluding the 2 directors. And in February 2020, we managed to open an office in London, Mayfair. March 2021, we moved into our newly purchased offices in Leicester City Centre. And we are now Leicester's largest independent estate planning company. And we also provide regular reviews with our clients. So once we've supported our clients, we don't forget about them. We will do regular reviews to make sure that everything is still in order and they have the most up-to-date will. So services we offer wills and we offer trust. Trusts are then created to support the will. To give you a bit of a background about wills, a will is a legal document that's created to then put down your wishes of what should happen to your estate after you pass away, who you want it to go to, okay? How you want that to be distributed. But the will itself won't protect anything. So if you're looking to protect assets such as your house, money, in that kind of situation, you would then look to create a trust. We'll also provide you with inheritance tax advice. We can support you with lasting powers of attorney, and then we will then do the end part of the work, which is the probate element. This is when an executor has to step in and then tidy up your affairs to then be able to distribute all of your estate over to your beneficiaries. The type of trust that we do, these are the type of trust that we do where we do protected property trust, right to occupy trust, and we do a lot more than this as well. One of the most important ones that I've been dealing with recently is a disabled vulnerable person's trust, where somebody, let's say I have a client and they have a disabled child who are on means tested benefits and are receiving benefits. If their inheritance was to receive into their personal account, their benefits will stop. And the government would ask for the child to be then using up all their benefits before they can receive any kind of, use up all of their inheritance before they can receive any further benefits. At that time, because their benefits are stopped, they would have to reapply for a means tested benefits. And if you've got a child that has learning difficulties, for example, they may find it hard to then reapply for those benefits. Therefore, a disabled vulnerable persons trust would support them. And if you have any further questions, feel free to then get in contact and I will talk to you about the other kind of trust that we have in place. So some interesting facts for you firstly. In UK and Wales, if you have assets or savings of more than £23,250, you have to pay for your care home fees. Cost of care can be from £55,000 per year. On average, 60% of people that die each day haven't got around to doing their will. And that's when the government are rubbing their hands because there's a lot of inheritance tax that has to be paid. Cost of funerals is increasing by 7% per annum since 2004. And believe it or not, spouses do not automatically inherit the estate fully. And creating a will doesn't always guarantee your loved ones will always inherit. So some of these kind of facts that we compile together to try and help you understand the importance of creating wills. Now, you're probably asking yourself, why should I make a will? Perhaps it's better for me to consider the implication of not making a will. Okay, so this chart over here, this flow chart that I've created here, is what happens if you die without a will in England and Wales. So if you don't have a will in place, you follow the laws of intestate. Okay, and following this flow chart, it will tell you exactly how your estate will be distributed if you don't have a will. Now, if you are married or in a civil partnership and you have children, your spouse or civil partner will receive personal possessions. The first, it is now 270,000, not the 250 that's on the screen, 270,000 together with interest from the date of death and one half of anything that remains. Your children will then receive the other half of anything that remains. Now, in the event that you aren't married or in a civil partnership, then it will go down the following flow chart to see, A, do you have children? Then looking down to see if you have any living parents, if you don't have any children. If you don't have any living parents, then do you have any siblings? Now, some people don't have siblings, so then it will look to go to the grandparents. Now, if the grandparents have passed away, then it goes down to living aunts or uncles. Now, these could be people that you don't really get on with, and they could end up inheriting your estate. If you don't want to do that, and you don't want it to happen, then you need to look to create a will. If none of these triggers are activated, then it will go down to the Crown. Now, national statistics show 70% of population don't have a will. 30% do have a will. However, does it do what they want it to do? The reason that I put this on is that a lot of people will look to go for the cheapest option when it comes down to writing a will. The will is probably the most important document of your life that you're ever going to create, because all this hard work that you've done throughout your life, where you've bought a house, got lots of money in savings, and you built this estate up for your family, you're now going to then scrimp and then pay for the cheapest type of will to try and see, make sure that it goes to your beneficiary. Now, I can assure you right now, we work with a lot of firms in the UK, and they do pass us a lot of wills that have been created on the cheap for people. We review them and find out that it hasn't been fit for purpose. So what we can do is do a free review for our clients and support them to see, is that will fit for purpose? And if it is, we will tell you that it's fit for purpose, but we'd like to stay in touch with you to see whenever your circumstances change, that we can help you to create a new will for you. Now, what I'd like to do is tell you what would happen if you don't have a will. So to my family, I hereby leave you all several months, possibly years of financial hardship and expense whilst you go to unnecessary lengths to sort out my affairs. What this means at the time is that because I didn't create a will, I didn't leave an executor in place. The executor is a person that's going to tidy up my affairs, sort out all my creditors, debtors, and any taxes that need to be paid, and then pass over the estate over to my beneficiaries. But because I didn't do a will, I've left it to my family to sort out. To my spouse or civil partner, I hereby leave you some, but probably not all, of what I own, because they will only receive the first 270,000, as I said before, from the law of intestate. To my children, I hereby leave you the remainder of my estate and give you the authority to enforce the sale of any part of it, including the family home, to realize your inheritance. This next part is the most important part to me. Okay, I have young children, so this really hits home to me all the time. So to the social services, if my children are orphaned, I give you the authority of guardianship and the power to choose who should look after them, including allocating them to foster parents. So the law is in the UK, you have children that are under 18, both parents are to pass away, then the local authority will step in. They will then choose who is going to look after your children. Now, it could be that they end up in foster care for the rest of their lives. If you have multiple children, you'll find that most foster homes won't be able to take all of the children in at once, meaning that your children will then split up. So this is so important that you always make sure that you have set up a guardianship. And one of the only ways that you can do that is through a will. To the taxman, I hereby leave you all the tax that I could have avoided and given to my family. When working with a firm such as ourselves, what we'll be able to do is not only create a will for you, but be able to see if there's any inheritance tax that your heirs will have to pay. You don't have to pay that, but your heirs will have to pay that when they receive it. And until the inheritance tax has been paid, they won't receive their estate. What we can also help you do is try and see is there a way to try and look at mitigating the inheritance tax situation if possible? Okay, we work within the law and we look at all the ways that you can maximize on any inheritance tax that could be coming. Now, to the local authority, I hereby authorize the local authority to force a sale of my house and to liquidate any investments I have to pay for my care and save the local authority funds for projects more important than me. To the children and grandchildren, I hereby authorize you to ensure that if the children and or grandchildren get divorced, that half of what I left them is payable to the ex-in-laws. After the divorce proceedings, and then they have ample money to look after the new spouse and any children they may have. To my bank or building society and solicitor, I hereby authorize you to charge whatever you feel necessary to sort out the mess that I've left behind. I realize that this could make you one of the major beneficiaries to my estate, because they're going to then charge whatever they want to make sure that all of these affairs are wrapped up, because there's no control in it, because there's no terms and conditions that were set up. And to everyone else, I leave you nothing, because by this stage, nothing is going to be left behind for anyone else. And these are the main reasons that we would state that you need to look to create a will. So some of the reasons for needing a will: over 50s, looking to protect against care home fees. Once you get to 50, people then start looking at the lifeline and looking at what kind of future risks are involved. They may have worked really hard, paid off their mortgage, and now they own their property outright. And they want to then make sure that stays within their legacy. But the potential is that potentially with health reasons increasing in the UK, that their health could deteriorate and they could end up going into care. Now, if that's the situation and they can't afford to look after themselves and be able to pay for the care home fees, then the government can look to use the house as collateral to be able to pay for the care home fees. Unmarried couples who are homeowners will be looking to need to create a will. And couples with children from different relationships or children even that are under 18 should have a will created to make sure that guardianship has been put into place. Some of the 5 common reasons of why people renew their wills is because they have children, got married, moved home, got divorced, or received an inheritance. Okay, so I've talked about wills, and what I'd like to do now is introduce a trust to you that would then help protect the house from something called sideways inheritance. So we have a situation where we have a couple, a married couple, and they have 2 children of their own. Now they have their own home, but however, a couple of years after being married, wife passes away. Husband is upset, but then a couple of years later, as you can see, after the probate has been completed, the house will then go over to the husband in this situation. Husband then moves on and meets his new partner. This new partner has her own children. Now in this situation, husband has now passed away, and all of this estate, the house that the first couple have built together, now moves over to the new partner. And when the new partner dies, it moves over to her children. And what this means is that this is where sideways inheritance meaning comes from. it means that the original children from the original relationship who lived in that house, were brought up in that house, won't be able to see that house ever again because it's gone down a different route, because the provisions weren't put into place. So in this situation, we create something called a protected property trust. In this situation, we sever the tenancy of the property and we make the property a 50-50 situation. 50% belonging to Mr., 50% belonging to Mrs. The house is still 100% theirs, but in the eyes of the law, it's now showing that they both have a 50% share. Now, one of the first things that we can look at of where the protected property trust comes into play, let's say, for instance, Mr. goes into care, then rather than the charges being put against the whole house, it would only be put against Mr.'s 50% of the house, which then means that Mrs. can continue to live there until she dies, and then when she dies, her 50% will still go to her children. Now, in the situation, Mrs. passes away, okay, then her share goes into a life interest trust. So that means her 50% straight away locked in a life interest trust in preparation to pass over to her 2 children. Now, if Mr. moves on and meets his new partner again, and she brings her children, and Mr. dies, then his share will also go to his children and not to the new partner and not to her family. Okay? And that means that the kids will always have a life interest in that property and they will always inherit 100% of that property. Okay? A standard will alone will not do that for you. And in order to make sure that happens, we need to put a protected property trust into place. Okay, so that's wills. And now I'd like to talk to you a little bit more about lasting power of attorney. It's a myth that close family or friends can automatically make decisions on your behalf if you need them to. A lasting power of attorney means someone you trust can quickly, easily, and legally step in. You keep control by deciding who can speak for you, when they can speak for you, and what they can say. Okay, these have become extremely popular in the last 2 years, especially since the pandemic. Okay, if you think of a situation such as when the pandemic first kicked in, Boris Johnson went into hospital for a period of 2 weeks. If that was you and you had to go into hospital for 2 weeks, who would manage your finances for you? Who would make sure your bills are getting paid? Who would be making sure that withdrawing your pension, for example, if you're withdrawing a pension? Okay, these are kind of concerns that be going through your head. If you have children at home, who's making sure that there's money coming in at that time from the bank account and making sure there's food on the table? Okay, so some questions for you. True or false? If a couple have a joint bank account and one person can't make decisions for themselves, their partner can legally make decisions for them. True or false? Well, the answer on that one is false. But 73% of people that were asked, people think it's true that the partner can just start making those kind of decisions for them for financial reasons. If you're in hospital, your next of kin can always get the final say in treatment decisions if you can't make them for yourself. The fact is, it's false. And 72% of people, again, think it's true that their loved ones can then make those kind of decisions on their behalf. If you want these kind of situations to occur, then you do need to create something called a lasting power of attorney. Okay. So there's 2 types of documents for a lasting power of attorney, one for financial decisions and one for health and welfare. So the one for financial decisions is a finance and property lasting power of attorney. Gives someone you trust the power to make decisions about your money and property. For example, paying bills, managing a bank or building society account, collecting benefits or a pension, selling your home. These powers can be used at any time, but only if you say it's okay. And with all powers of attorney, you can nominate a minimum of 2 people to act as your attorney and no more than a maximum of 4 people to act as your attorney. The attorneys will only step in when you want them to step in. These documents are registered with the Office of Public Guardianships. So what they will do is monitor your lasting power of attorney. And if there's any kind of misuse done, you can report it to the Office of Public Guardian, who will then investigate that with you. A health and welfare decisions. A health and welfare lasting power of attorney gives people the power to make decisions about things like your daily routine. For example, washing, dressing, and eating. Your medical care, moving into a care home, life-sustaining treatment. Again, you can apply and register it immediately, but it's only used if you can't make your own decisions in the future. These are kind of even simple things like if your parents are going into care, if you're their attorney, you can then demand what kind of care that they receive. You can demand for your parents to be brought back at home and the care come to home. You can make all those kind of decisions, but only because you have a lasting power of attorney in place. If you don't have a lasting power of attorney, unfortunately, you won't be able to make those decisions and someone else has to do them, whether they're right or whether they're wrong. Now, if you don't create a lasting power of attorney and you do lose capacity, it's not all doom and gloom. There is another avenue that you can go down. This is called a court of protection. Now, the court of protection is quite difficult to obtain. It's probably 3 times more than what a lasting power of attorney will cost and take about approximately 10 months to create that document. And in addition to that, when you can then create a lasting power of attorney for financial decision and health and welfare, the court of protection will only allow and grant you access to create one for financial decisions only. Now, when the court of protection is granted, there's lots of terms and conditions that come with it. And the attorneys have to keep a lot of track records and send these details into the Office of Public Guardians. It is hard work to work with the court of protection. The easiest way to deal with all the affairs is by creating a lasting power of attorney. Okay, so thank you very much for allowing me to create this presentation. These are some of my details, which is my email address, our website, and my Facebook page. Feel free to log on at any time, especially on my Facebook page. I deliver lots of hints and tips about and educational pieces about wills, trust, and lasting powers of attorney. And if you ever have any questions, you can either ask me on the main pages, or you can then inbox me directly, or you can contact me on my telephone number. And that's my presentation on wills and lasting powers of attorney. I'll pass it back over to Amir.
Thank you very much for that, Jay. We do have some questions, and we're going to open it up for Q&A. So I'm going to jump onto the chat first and ask the questions from the chat, and then we'll follow through with people putting their hands up, and then we'll let each and everyone have an opportunity to ask the question. Okay, so the first question is from Sanjay. He says, Jay, what's the difference between tenants in common and a protective property trust?
The tenants in common is allowing for the severance to happen. So the tenants in common will allow the severance to happen so that you have the 50-50 split. The protective property trust is then the added level of protection to avoid sideways inheritance.
Thanks a lot for that, Jay. The next question is, can you nominate LPA nominee be based, can your nominated LPA nominee be based abroad and not in the UK?
Sometimes lasting power of attorney can work abroad. It depends on the country's regulations at that time. So you would have to check that the UK lasting power of attorney will work abroad. But we do liaise with a lot of solicitors that can help us create a lasting power of attorney for our clients over in India for their India assets. In addition to that, what we're also able to do is, as a firm, we're able to create India wills here in the UK. So rather than having to go to India, appointing a solicitor over there to create a will for you, we can do that over here. And myself, I speak fluent Gujarati, so I can speak to my clients in Gujarati and try and support them that way. And a couple of my colleagues, they also speak in Punjabi, so we can help our Punjabi speaking clients as well.
That's great. The next one is, does the lasting power of attorney allow you to sort out finance, bills, bank accounts after death?
No. So how a power of attorney works, so the way you look at these two documents, are they're two different documents. Lasting power of attorney will work for you up until you pass away. The day you pass away is the day that your lasting power of attorney dies with you. At that point, your will kicks into place, and then your will then starts making decisions of what happens after you pass away. If someone is still activated the power of attorney and still using the power of attorney right after you pass away, it will be classed as fraud.
Okay, useful information there. The next one, I think you've already answered this, but I'm going to ask it again. does UK will also work for properties in India or out of UK?
No, you have to create an India will. We can support you with that, but you do have to create an India will. Now, if you've got assets in India, if you were born in India and you've got assets in India, then they won't be classed as worldwide assets. So they won't add to any kind of inheritance tax burden in the UK. Okay, so that's quite important to understand. However, if you weren't born in India, you have assets over there, they'll be classed as worldwide assets and they'll be added to any kind of inheritance tax burden that you have in the UK. Okay, because it would add that money to your estate.
Thanks for that, Jay. If there are anybody else who wants to ask a question, please raise your hand and we'll give you the opportunity to ask the question.
Hi, this is Chandra here. Just a quick question. What sort of a timeline, from inception to delivering this bill, if you from your first meeting and, to get all this in order, how long will it take? That's my first question. And the second question is, right, say if I have 2 or 3 properties, right, and, I may sell a property and I buy another property. Is that that's where your regular review, annual review kicks in, right? Should we keep doing anything about it? Can I ask one more question if you don't mind? But answer if nobody else is having the question. The business assets, right? Do they need to be covered part of it, or is it something separate we need to create? Thank you.
So the first question, I believe, was the timescale. So let's say, for instance, I came to meet you today and you were quite happy with my recommendations of what needs to be done to create a will. We will provide you with a service agreement and a payment form which you need to complete. We will then, once the service agreement has been retrieved by myself, we will start working on your will for you. Within 14 days, we would have a draft ready for you. However, that 14 days can be escalated very quickly if there is an emergency for the will, such as you're going to go abroad, or you've got terminal illness and you haven't got much time to live. We also deliver deathbed wills as well. So people are dying on the deathbed, we will go over to create a will for them and try and turn that around before they pass away. So we can do those kind of services for our client. Now, when you said about the reviewing side of things, which was your second question, we offer a service called a storage service, will storage service for our clients, where we would store the original will and provide you with the copies. Now, wills are still an Old Testament document. Now, what that means is that they're still old style documents where only the one original with the wet signature is the only one that can ever be enforced. Okay, copies will never be allowed to be used in court. Now, because of that, if you damage the will, if you lose it, it gets destroyed, then the will becomes void and then it goes down the law of intestate. So for that reason, we created will storage, where we would store your will, put it in a secure unit, in a fireproof, floodproof safe, cover the will for up to £2 million. And then for that service, you would pay an annual fee. Annual fee is very minimal. It's not very much at all. And for that annual fee, what we'll also be able to offer you is unlimited amendment. So once you've paid your fee, anytime you need to update your will, you simply contact me and we will update it for free for you. And all that will be required at the time is the will signing and the will witnessing. And then again, we will put that into the storage again, because you're paying the annual charge, and then provide you with the new copies. And at that point, your old will no longer work because we've revoked it, and your new will be enforced at that point. And regarding the business, depending on the type of business, we would look to add that into the will, but we would also be able to protect by creating business relief trusts as well, where we can ensure that a percentage of your business doesn't have to pay any tax when you go to sell it. So there's a lot of things that we can do, but it's important that we have a thorough conversation with you to try and understand your needs and what your requirements are, what you're trying to get out there, and then be able to make the most suitable recommendations. The way I explain our services, we provide a non-advice level of service where I can give you advice and guidance on how our products work. Based on the information that you've provided us, we'll give those recommendations, but then it's up to you and your family to decide on which recommendations you want to go for, if any. And we would never force you to go for anything, but we need to make thorough note about what options you've gone for based on what we've decided to provide you with.
Thanks a lot.
Hopefully that
Yeah,
answers your questions.
it's very, very informative. I have one question, but I'll keep it
go
until
for it.
last, like other people finish that. Probably I know like you may have other questions.
Thank you, Chandra. Okay. The next question posted is, if I was to have an LPA for myself in the UK, can I nominate a sibling in the USA or Canada?
You can, but I would say it's not the most feasible way of doing a lasting power of attorney. The reason that you're creating lasting power of attorney is if you lose some form of incapacity, someone can immediately start interacting for you. That means dealing with your banks, dealing with the healthcare, so on and so forth. Now, if your relative is in America, you've got time differences straight away. So that's going to delay matters. So these kind of factors, yes, it can be done, but we would strongly advise not to do that and look to appoint someone that's based in the UK and more specifically nearby to where you live to try and support you in those kind of times.
Thank you.
Hopefully that helps.
Yep. The next one is, inheritance tax only applies after second death?
Well, yeah, it depends on how you create a will. So if you're a couple, if you're a married couple, what we strongly advise is to create something called a mirror will. Okay. And the benefit of a mirror will is that on first death, the surviving spouse would inherit everything 100% tax-free. It's the smartest way to do everything. Okay. If you don't have a mirror will and you have separate wills, then you're forfeiting a potential £650,000 that you can pass over to your children through the nil rate band. So we would always strongly recommend to create a mirror will to support on this kind of basis.
Right, thanks. I think you've already answered this, but again, I'm going to re-ask it. What about NRI assets in India?
So again, that will be covered under the India wills. Anything that you have in India, whether you were an Indian national or not, because you've got assets in India, you need to create an India will. I can't stress that enough. It's really important, especially most of you probably know, what happens in India when you've left assets alone there, especially homes where relatives start moving in and they want to leave, those sort of things. You need to have that in place because maybe you're able to go back and forwards to India because you've set up that home. When you're going to leave it to your children, how often are your children going to go over there? And then when they do get over there, how easy is it going to be for them to be able to retrieve their own assets without putting up a fight? But if you had that will in place, you've got that legal document that you take to court and then you can do what you need to do.
Right. Next question is it best to have a joint will?
If you're a married couple, 100% a mirror will is strongly recommended.
Okay. The next one, are both types of LPAs equally important?
I would say yes, they are. Because first of all, you don't know when your health is going to be affected. And when we're talking about health, we're not just talking about illnesses. It could be, I don't know, you could be crossing the road and you could have an accident. And again, you can be incapacitated. You can fall down the stairs and be incapacitated. Your health is being affected at that point. And then the property and finances, especially if you've got multiple properties, multiple bank accounts, multiple insurances, pensions, so on and so forth, you need someone to manage that for you, especially when you're incapacitated. So if you can't do it, the other person has to step in. But I will always tell the clients, in the first instance, which ones do you feel is the most important to you? And 90% of my clients would normally say, both of them are important to me. Yeah, because I don't want doctors making decisions for me when my family knows what should happen to me if I'm ever in these kind of conditions. Life-sustaining treatment, medical treatment, medications that they need to take. So these kind of things have all got to be thought about. And what I always say to my clients, don't look at the financial side of things, of how much everything's going to cost you. First, look at what does everything do that Jay's recommended to me? And then what's going to work for my family? I strongly advise any person that's looking to create a will, they have children, obviously children that they want involved in this, to have the children present as well. We don't have anything to hide. And it's the children that are going to benefit from the estate after they pass away, whoever the beneficiaries are going to be. And it's important they're involved in this kind of decision making. To a certain degree, it is the client's decision of what happens to the estate, how it gets split. But if they need to be protected by trust, then the children need to be involved to see what the benefit is to them. So I would advise the family being involved in this. But again, only if the clients want their children to be involved with this. Some clients wish their children not to be involved because they don't want them to know about this just yet. Okay.
Yeah. Okay. I know, Renuka, you've been waiting for a while, so do you want to unmute yourself and ask your question?
Hello?
Yeah, we can hear you.
Yeah, you can hear. What I wanted to ask you, to cover the inheritance tax, would it advise will be to buy an life insurance for the person?
So it's a really interesting question. What I normally like to do is to understand how that estate looks and what the inheritance tax issue looks like. Sometimes you may think there's an inheritance tax bill, but there may not be because there's other debts that need to be taken out of there. You can take out something called a whole of life cover, which I think you're pointing to. Yeah. Whole of life cover would then only work if you've got enough cover to pay off the inheritance tax. But on another front, what it might be able to do is reduce a big chunk of the inheritance tax that needs to be paid for your children. There is multiple ways that you can look at inheritance tax. Life cover is just one factor of it. There could be certain trusts that could support. There could be other kind of tax planning that we could support you with to try and look at reducing the amount of inheritance tax that needs to be paid.
Thank you.
No problem.
Okay, going back to the questions. The next one, I think this might be something that you might need to take offline, but I'll ask it anyway. Could you go through the approximate costing of doing all of this?
Yeah, so if you're looking at a single will, our fee would be £175 plus VAT. That's for one person. If you did a mirror will, it would be £250 plus VAT. Okay, and it's a flat fee. We don't have any additional charges when it comes to the will. So if you're looking to make additions to how many beneficiaries they're going to be, unlike some companies, we won't keep on adding the cost to that. It is that flat fee that we're going to be charging you. Okay. When it comes to the trust and the lasting powers of attorney, they will all have their different pricing structure. And depending on what you require, I would then go through those kind of costings with you. But if you have any queries about the costing, please feel free to call me and I will go through that with you. But the reason I don't like to go through all the costing is that people start making up assumptions of what the bill is going to be, then they don't do any of the planning. But it could be that you may not need all of this, and I might not be able to recommend all of this because they're not going to support you in any way. So it's important to have that educated conversation with ourselves to help you understand, first of all, for us to understand what your needs are and what your requirements are, and then to make the recommendation on the back end of that.
Thanks a lot for that, Jay. The next question is, how does a mirror will work? Is that fit for purpose for property assets?
Yeah, so the main benefit, as I said before, for a mirror will is to ensure that the surviving spouse receives everything 100% tax-free. Okay, without a mirror will in place, there's potentially the surviving spouse could end up paying inheritance tax on their own estate, and that's why you would create a mirror will. Okay, if you're a couple, you want to create a mirror will, but the benefit of a mirror will is that you can have individual wishes within your own element of your will. So there's a Mr. and Mrs. married. They want to do a mirror will to make sure everything's passed over 100%, but they may have some slight little tweaks in there to say, if I was to be the second person that passes away, I also want to make sure that certain amount goes to this charity or to my brother, to my sister, so on and so forth. They can make those individual tweaks within that if they wanted to.
Right. The next one is, can you provide some general info about vulnerable person trusts, please?
Yeah, so let's look at the situation. Let's say client A has a disabled child with learning difficulties as an example. Now, in that situation, that child that's receiving that has learning difficulties is receiving means-tested benefits. Okay, and they're getting government support to support them with their learning difficulties. Now, let's say, for instance, we don't have a vulnerable person's trust into place. What would happen is when the client dies, everything they've left for that child will go into their personal account. Now, because that money's hit their account, the government straight away sees that this person's got enough money in their bank account to survive on. They don't need any support from us. Straight away, overnight, everything stops. All the creature comforts that they were used to, a bus picking them up, taking them to school, all of that will stop, and they've got to fund that themselves. Now, if they've got learning difficulties, how easy is it going to be for them to be able to do that? So what we would do is create a vulnerable person's trust. And in that trust, what we would do is when the client passes away, everything that they're leaving behind for that child will go into that vulnerable person's trust. Okay? At that point, they will continue to receive their benefits and continue to get the government support. The added benefit of that money going into their personal account is, let's say they had to go to a special home. Rather than going to a home that's not really looking after them and the facilities are not great, they can go to a better one. And the money that they've got in the vulnerable person's trust can top up the bill for living in that home at that time. So the vulnerable person's trust for someone who's got vulnerabilities or disabilities and is on means-tested benefits is probably a must. It's probably as important as the will, in my opinion, from dealing with these kind of cases.
Great, thanks a lot for that. The next one is, if you already have a simple will in place, how can you go about upgrading it or moving it?
Okay, very simple. You don't upgrade it, you don't move it, you just talk to me. I review it to firstly see, is it fit for purpose? Now, sometimes a simple will might be fit for purpose, okay? Where a simple will come in is if you have someone with an estate less than £50,000, I would say, a simple will work for them, okay? That means they probably haven't got a partner, they probably haven't got a house, they haven't got much of estate. And in that situation, a simple will be straightforward that says, when I die, all this little bit of money that I've got or whatever I've got at that time can go straight to whoever. In that situation, it will work. What it won't do, though, is if someone tries to contest your will, give you any layer of protection. That's where a company such as ourselves will step in. When we create a will, we have to make extensive notes about the conversation, even to the detail of what your health was like at the time, how you were dressed, what your appearance was like, how you conversed with me. Did you make your own wishes? Was someone else answering for you? There's so much I have to write up. And for admin, it's crazy for me. However, all those notes are very detailed. The reason being is, if at any point, if anyone ever contested your will, we can go into court and say, that person was a sound of mind at the time, and these are the reasons why. And we have a little bit of a story telling why the client came to this decision at the end. So I would make recommendations to my clients, and my clients would decide on if the recommendations would be appropriate for them and their family. Now, if the clients have said no, I always ask my clients to email me back to say, why do you feel that the recommendations weren't suitable for you at this time? And they would tell me, and I'll make those notes. Again, it's showing to the courts, if at any time the will gets contested, that the clients were of sound of mind and made these decisions. It also backs us up if the children turn around to us and say, well, we've lost this, this, and this because of this, this, and this. But I go, we did give the options to your parents at the time, but they decided not to go with it. Okay. And this is the kind of times where you now need to start thinking that, okay, it's costing me a little bit of money, but why am I doing this? I've worked this hard to build up a £500,000 house. I've got £500,000 in the bank account, that sort of stuff. Now, in that situation, do you think it's worthwhile scrimping and saving on a cheap will and things that won't get done properly for your beneficiaries? Or do you want to make sure that the right thing happens for your beneficiaries? If that's the case, then you need to sit down with a firm such as ourselves to be able to support you in these kind of ways.
Great, thanks for that, Jay. The next one is, do I pay inheritance tax if I give money to my son and I live for over 7 years?
So gifting, the gifting rule is that you can give something in your lifetime, anything over £3,000 has to go through the process of a 7-year ruling. So how that would work is, if it's been less than 3 years and you die of giving that money, then the tax rate would be at the maximum of 40%. If it's between year 3 and year 4, then the tax rate that will be reduced down to 32% that would have to be paid on the money that was given to them. Between year 4 and year 5, the gift will be taxed at a rate of 24%. Year 5 to year 6, the tax would be 16%. And year 6 to year 7, between the gift and death, 8% tax rate. And then year 7 onwards, there's no tax that needs to be paid on there. Okay, so yes, it's great that you can gift that, but you've got to make sure that you survive the 7 years in that time as well. Okay, another thing, while we're talking about gifting, I get a lot of inquiries where parents are ringing me to say, Jay, I'm worried about this, I'm worried about that. And what I want to do is sign my house over to my son at this stage, or sign it over to my daughter. And I go, don't do that whatsoever. Okay, there's a couple of reasons why, and they're very logical reasons. Simply is, if you transfer it over to your child and they go through divorce, as it's their personal assets, that house will now go through that divorce. And if you were living in that house at the time, you're potentially now going to be homeless at that point. If your child becomes gets into financial difficulties, okay, those charges are going to be registered against the house. If the house has to be repossessed, again, you are going to be made homeless. So I strongly advise you don't transfer the property into your children's name at any point while you're alive, especially if you live in there. However, we could then potentially support you with products such as a lifetime trust, where we can put the house into a trust and protect it from those kind of situations, such as care home fees, probate fees, third-party attacks, bankruptcy. Those kind of things will be protected from things like lifetime trust. But we can't just give that trust to you. I've got to understand, is it a suitable product for your family? If it is, I will make those recommendations, but I will tell you the pros of it and I will tell you the cons of it as well. So you have the full story to decide, is this a worthwhile product for us to then take out at the time? And it needs a little bit of time to think about, from my perspective, do I offer that to you? And would it be the right service for you as well? We're not just going to offer you a product because it makes us money. That's not how we work. You know, we've got families as well, and we want to make sure that your families are treated in the way that I'd want my family to be treated.
Great.
And I like to treat my family well, just in case you're wondering.
I should hope so. Okay, the next one is, how can you change a nominee in an LPA, or do you need to have a new one?
So we can go through something called a revocation. So we can appoint a revocation letter to go over to the Office of Public Guardians, and then we can then set up a new power of attorney for them with the new nominated attorneys.
Right. Okay. The next one is, what information required documents to provide a draft will? So
nothing really. So simply the kind of things that we're looking for when taking your instructions. We need your full name, address, date of birth, those sort of things, your standard things, personal details. Then we need to know about how many children you've got, and we need your children's full details, name, address, date of birth. We need to know about assets that you have, houses, money, businesses, those sort of things. Then we need to then understand who the beneficiaries are going to be, what the split looks like, who you're going to appoint as the executor or trustee. In our opinion, we always advise that you use a professional executor. The reason being is that they have liability insurance. So if anything goes wrong, the insurance will cover them and ensure your beneficiaries still receive their inheritance. When someone individually is doing that and they make mistakes, they can be personally sued by companies involved. And for that reason, if they don't have liability insurance, you could be putting them in a lot of bother at that time. You can also be taking away a lot of time and a lot of money for them to be able to resolve these situations that they may not know how to do. Sometimes, if the estate is very simple, I will just go back to the client saying, rather than paying a company such as ourselves, just do this, this, and this to get it resolved. But once it's complex, you probably need our firm to then step in to say, be the executor. So you need to appoint your executors and trustees through that. Then you look at your beneficiaries. But what we also like to do is look at creating a bloodline will. So as an example, we've got a couple and they have children and they have grandchildren as well. Now, let's say the couple's child passes away, then that child's share would then move down to the grandchildren. Okay, and that's what we call a bloodline will. And they can appoint when the grandchild or the child receives their inheritance. Through a standard will, you can choose anywhere between the age of 18 and 25. But remembering, through a will, once you've nominated that age that they receive their inheritance, they will get that inheritance. There's nothing you can do about it. So if they're off the rails, let's say the son is on drugs and drug dependent, if you're leaving them an inheritance at 25, they're going to inherit that. But the danger is they're going to use all that money up towards the bad habits that they have. So what you can do is create something called a discretionary trust at that point. A discretionary trust is a way of controlling the money and the assets once you've passed away. So you're still in control of your kids at that point. So you may point that at 25 that my children receive my estate. However, you can put a clause in that. If my child at the age of 25 is into drugs, drink, gambling, in those situations, I don't want them to receive the money. If they're not working at the time and they're refusing to work, I don't want them to have the money. I don't want them to rely on this money that they give up on life. So you can make all those decisions at that time, but that's by appointing a discretionary trust. Another added benefit of a discretionary trust would be that once the money has gone into the trust, your children can manage it through the trust and they can use it like a bank account and take out as little or as much as they want from there. Again, it's protecting your children from third-party attacks, divorce, bankruptcy, financial hardship, all those kind of things, and making sure that they don't lose the inheritance that you've given to them. Okay, so those are the other things that you can do. So we can put reserve beneficiaries in place as well, which is what I call the disaster clause. So let's say the clients and their children pass away and there's no grandchildren. In that situation, if all of them died suddenly together, then where would they want their estate to go to? At this point, they can appoint things like charities, they can appoint other family members. You know, think about those family members that you know that are not well off in your family. Would they benefit from this estate coming over to them at that time? Would that change their world? But then, and then if you want that to happen, then maybe you should appoint them as your reserve beneficiaries. So these are the kind of things that we need to take from you. ID-wise, what we need is a photo ID, and the easiest ID for us to take from you guys at the time is a driver's license. The new driver's license with a picture on it, because it has your photo, your name, address, and date of birth on there. If you don't have the valid driver's license, it's not a problem. A valid passport with a recent utility bill or bank statement will be suffice.
Great, thanks for that, Jay. The next one is more on the personal level. Is it, do you deal with people outside Leicester? Would you be able to meet online? On a one-to-one basis?
So what we do is we do actually cover the whole of the UK. Further afield, we'll do Zoom meetings with our clients, but within the Midlands, we'll normally go and do face-to-face visit if that's suitable. But the Zoom meetings work just as well. It's like me being in your house without invading your personal space. But if you want that face-to-face meeting, I've had meetings at clients' home. We brought clients into our offices because we have meeting rooms there. I've even had meetings in coffee houses with clients as well. Okay, we'll try and work around you to try and support you in whichever way that we can. And also to make you aware that our firm, with that first initial meeting, it's a free consultation when we come to take your instructions as well. So there's no charge from there. We'll sit down with you, take your instruction, and then give you your recommendations at that time as well.
Great. That last point actually cleared the question that I was just about to ask. Is there a charge for the first consultation? So you just qualified that. Yeah. The next one is a bit of a kudos for yourself. Somebody has stated that they would personally like to recommend you in helping their family members in updating their wills. Very professional and personal, 5-star service. So thanks, Jay. Keep up the good work.
Thank you very much.
Okay. The next question is, once both spouses die following a mirror will, which state children benefit equally? What sort of recommendation could reduce the inheritance tax?
Again, we'd need to sit down to try and look at what avenues we're going to use to try and to mitigate inheritance tax. There's a lot of ways that we can do it. Now, the more complex they are, the more expensive they're going to be, because there's going to be a lot of work that goes behind the scenes. And at these kind of times, we're going to probably have to sit with a trusted financial partner that we work alongside to look at what's the best avenue for that. So again, it's going to be one of those situations where we need to sit down, take instructions, and then look at how we're going to plan it. There's not a blanket approach on this.
Right. Somebody by the name of iPad just raised their hands. Do you want to unmute yourself and ask your question? iPad, you're on mute.
Okay. Hi, sorry. Are you a firm of solicitors?
Yeah, so what we are is, we're not actually solicitors, we're actual estate planners, but the guarantee that you get with us, we are step practitioners, okay? So the best way to explain what a step partner is that we're regulated by the Society of Trust and Estate Practitioners. So they are the accreditation that our will writer needs to have in place to give us the kudos that we need to be able to do what we do. Because of that, we're able to give you estate and planning requirement provisions and advice and guidance on there. We do exactly what a solicitor does, but we just don't have the solicitor charges. And to give you that reassurance of why you come to us, we have law firms in Leicester, London, Manchester, and now slowly moving into Birmingham. We have those law firms that are actually passing their will writing business over to us. Because what the solicitors normally says to us is that, Jay, you can offer a service that we can't offer to our clients. Because to a solicitor, for most solicitors who don't deal with wills and probate, it's just a tick box exercise that they can do that. And a lot of them will tell you that. And I'm going to give you just a quick insight into a client I went to see just recently who called me over for inheritance tax advice. They didn't want a will because they had a will created. So there was a couple, husband and wife, they're in their 70s. Husband died 2 years ago. And the husband used to dabble in properties, had left 5 buy-to-let properties, and then they had a residential property of their own. The wife inherited everything. Now, when the wife inherited everything, she now created a will through a solicitor, and the solicitor simply took her instructions. And the wife's instructions were, the 5 buy-to-let properties, I have 5 children, give every single one of them 1 each. And the residential property split 5 ways. And I said to her, why have you done this? And she goes, I just thought it's fair that each child gets a property each. And I go, the dilemma with this is going to be the following. 5 houses going to 5 different children. One child might turn around and say, why did I get the property that's the least valued? Another child comes back and says, why did I get the property that's got the most amount of work that needs to be done on there? I can't afford to maintain it. And then it causes arguments between them. So the solution would be to put everything into one pot and then split it equally between them. However, this client, because of the amount of buy-to-lets that they had and the residential and the money that they were going to leave behind, there was an inheritance tax bill of £200,000 sitting there currently today for the children. So if Mrs. died tomorrow, the children, in order to get their estate, would have to pay a £200,000 tax bill. I don't know about you, but I know I couldn't raise £200,000 just like that. Okay, so we're doing a lot of tax planning with them. And we found a way that we're going to be able to reduce that tax bill and potentially make it disappear as well. Okay,
Thank you.
There's a lot of work that's going to happen in that, and there's going to be a lengthy process before that's going to happen as well.
Thank you very much.
You're welcome.
That's great. Thanks a lot for that, Jay. Okay, the next question. Where was that? Excuse me. You've already answered this, but again, just to reiterate, wills made in UK, is it valid in India? And the answer is no. Okay. The next one is, what's the storage cost of a mirror will?
Sure. So there's no VAT on this. For a single person, it's an annual fee of £30. And for a mirror will, it'll be £50 a year. So less than Netflix that you pay a month, you get more out of this. And it's manageable for you as well, that anytime that you want to make amendments, then we can then make amendments for you.
Great. That's all the questions that have been posted. Anybody else wants to ask any questions?
Just one more, Jay. I think it was very useful. Quite a lot of information has been passed down. Actually, I got a person visiting me next Monday, but looks like I have to ask him to hold on and come to you. Thankful.
Okay.
One question I think we talked about, as we are living, we are writing the wills, as we are alive, we can go and change all those stuff. But after our time, right? How is your firm is going to come and help our inheritance, whoever inheriting it, right? Because that's, I assume it's a process, right? Either, how the whole execution.
When you mean you would pass, so in your will, you would then appoint your executor. So if, for example, if you've appointed us as an executor, then in the will, it will state our company. And what we will do is we'll leave you with a lot of our contact details. And what we would say to you is share our contact details with your nearest and dearest, of who you trust. You don't have to share the will with them, but just our contact details, and say to them, if I pass away, this is the company that's going to be the executors on my will. Can you contact them? They will ring us, let us know who you are, and then we can then start acting on that on your behalf. Okay,
maybe a stupid question. What happens if your company doesn't exist at that point? Because we write the will, we stored with you. If a company go bust, right? Yeah. And what happens to our will? Because I know you have insurance, protection, and all of that stuff.
No problem. Yeah. So with the will storage, it'll never go bust because there's no debts registered against that. So we've separated our company into paradigm wills and the will storage. Will storage is standalone and there's no debts registered against that. Okay. If our company was ever to go bust and you wanted that reassurance, then simply the will be released to you. And at that time, whoever your beneficiaries are, once you pass away, they'll be able to make the decision of who they want to then appoint as their new executor at that point.
Thanks a lot.
No, you're very welcome. You're very welcome. Really good questions as well.
Okay, a few more have now come in, so let me ask them. If I already have a will, can it be changed by you?
Yes, it can.
Yeah, okay. The next question is the cost of your firm acting as executors, and how long does it take to finalize the process?
Okay. So we're a lot cheaper than a lot of the companies that are out there. So we have two ways that we can be the executors, one of two ways. We can either work on an hourly rate or we can work on a percentage rate. The hourly rate that we charge currently is £250 plus VAT an hour to be the executor. And the percentage rate is up to 1.5% as a maximum. Okay, depending on how big the estate is, the lower the percentage would be that we would appoint there. Okay, another thing to bear in mind is, use an example, we're very fair in the way that we work. Let's use an estate that's worth £100,000 and let's say we charge the full 1.5% on there, but the work that we did only cost us £750. That's all we would build the estate. We wouldn't charge the full 1.5%, which would be £1,500.
Great, thanks a lot for that, Jay. I've got a question for you on the executors. You mentioned before that you have to be particular about who the executor is going to be because there's potential of mistakes to be made. Can you give an example of what kind of mistakes can be made and what the repercussions could be of that?
Yeah, so it could be that debts that need to be paid, the debtors weren't paid on time. What that means is that years down the line, the debtors could then chase the beneficiaries and saying that you were the main beneficiary of this estate and your parents owed us this money that should have been paid when they passed away, but because it wasn't, you now owe us this money. And that could incur lots of arrears, fines, fees, so on and so forth. You could make certain mistakes where certain people didn't get paid, certain situations weren't resolved. And in that situation, if another firm that's attached feels that you've done wrongdoing, they can go after you at that point because you're the executor who's supposed to be finalizing this. It's one of those things that you've got to always ask yourself the question: if you wanted your teeth taken out, would you go to a dentist or would you go to a builder? Okay, and the answer always is going to be that you're going to go to a dentist, right? So in these kind of situations of finance, of law, do you go to a professional or do you go to someone else because you're trying to keep costs down? Okay, you're always going to ask yourself that question. And sometimes I will even say to people, it's really straightforward. Follow this process and you can get it done. It's fine. Once the estate starts getting a bit complex, I would always say you need to then get a professional involved. And we work with a lot of people, you know, we work with other law firms, we work with estate agents, we work with independent financial advisors, and so on and so forth. And we'll all work as a team to try and make sure that we get the best outcome for your family members at that time. And if you've asked us to be trustees, then we'll make sure that our financial advisors are trusted and making sure that they're investing in your money rightfully as well for your children's benefit, and making sure that they have a good inheritance amount when they get to that age of inheriting. One more quick thing on that, when it comes to guardianship, it's really important that you appoint the people that you know are going to look after your children rightfully, okay? And teach them the values that you potentially had as well. What will happen at that point is that sometimes we talk about trustees at that point, and then they will say, oh, we want to make the guardians a trustee because I want them to manage their day-to-day life expenses. I go, I get that. The dilemma with that can be is, if the guardian is having financial difficulty, what's stopping them from dipping into the trust account and using the money for their own benefit? They could be the nicest person in the world, right? And I'm not criticizing anyone, but the kind of things I've seen in my role, I've seen people who are the trustees who are dipping into the money and then taking away the money for their own needs and using the children as an excuse. I've seen executors withdraw money for their own needs because they're in charge of it and no one's governing it, okay? And that's why if you have an independent firm, a professional that comes in, they will follow the rules and guidance of how that will is set out and how those trusts are set out. When you create trust, you need a professional to come into play because they know how to operate the trust, how to activate it, how to make it work and make sure it does what it needs to do. Yes, sometimes you can get friends and family to do that because you want to save money. But do they know how the trusts work? Do they know the complications of it? Do they know the burden of how to reduce the money out of there before inheritance tax kicks in? You know, if they don't know how to do that, they're going to mess things up. It means, again, less money going into your children's pocket, okay? And these are the kind of reasons that you want to make sure that you use a professional firm to become an executor and trustee. But if you've not got the full faith in the firm itself, you can have a combination of our firm and your loved ones to all manage it together and do all the work together, so that if you feel that your family needs to keep an eye on the firm, they can do that at the same time. So you can have a combination. So with executors and trustees, a minimum of 2 executors, 2 trustees, or no more than a maximum of 4 people on there.
That's great. Thanks a lot for that, Jay. Okay, we don't have any more questions posted. Anybody else got any questions they want to ask before we bring the session to a closure?
And there's a lady that just raised her hand.
Renuka, you're on mute again, so if you want to ask the question.
Hello, sorry about that. Yeah, what I wanted to know is, can you have combination of mirror will in part of the estate out of that mirror will? So, for instance, you know, if my husband has got something that he wants to go straight to the children and not to me, can he do that? Can you have that sort of will as well?
Yes, you can. But what we would do is advise for that to happen on second death. The reason being is what we want to do is make sure the full tax allowances go over to the children on second death. So yes, in that will, we can then put down, Mr. wants this to go to the children, okay? But what we'll advise to do is try and do that at second death, okay? So we'll still go to the children, but it'll go a bit later on.
Okay.
But yes, you can through a mirror will, you can then split, you can make certain other requests that you want to do as well. So if you've got specific requests of where you want some of your money to go to, you can do that, yeah.
Okay, because, you know, I was thinking like, you know, say if my husband has got property in India and he wants to put it straight to the children, because first they're passing on. If it was mirror, I wouldn't get taxed anyway. But because he was born in India anyway, the first time it comes to me, it won't be taxable. But when I pass away, you know, anything that came from India investment, it would probably be passed to my children, and then they would inherit tax, isn't it? They would have.
So what we can do, Auntie, is that if your husband was an Indian national, he was born there, and he's got assets over there, by creating an India will, what he can then do is automatically appoint that the beneficiaries would be the children immediately.
Yeah, that's
so then it skips you, and then it'll go straight to them, and there won't be no inheritance tax burden.
Okay, fair enough. That's what I was
But in order for that to happen, again, it has to be an India will.
Oh yeah, that to be.
Yeah, and we can support you with that as well.
Okay. Do you? All right. So have you got people in India that you can recommend for us to do?
No, we'll do that from here. We'll do it from here.
Oh, you do it from here?
Yeah. So when I come over, I just take the additional details to create the India will, and we can then create the India will for you.
Oh, fair enough. So we don't have to go to India to get.
You don't have to go to India. I'll take away that pain for you.
Wow. Okay. Because we try to trust people in here to deal with the legal things, because India is a bit complex place.
Yeah, and this way it's safer to do it here, because then the will is kept here, and then it can be passed over to your children quite quickly as well.
Oh wow. Okay, fair enough. Yeah.
No, you're welcome.
Thank you.
That's great. Thanks a lot for that, Jay. Any more questions? Okay, we just had something come in. So is India will only required for properties invested there, or even if you have bank accounts in India?
Any assets that you have in India. Money, cars, houses, everything.
That's great. Okay, I'm mindful about the time as well. We're just over our allocated time. So I'm going to bring the session to a closure. Jazz, I know you're on the call. Do you want to take on the dues of doing the close down? Okay, maybe not. Okay, then I'll finish off the close down then. Jay, it's been a pleasure. Thank you very much. I think you've shared quite a lot of information which many of us didn't actually were aware of, and didn't even realize how complex things can get, when it comes to wills and LPAs. A vast amount of information has been shared, and that's been great. To everybody who's attended, thank you very much for taking your precious time and joining us. If you want to see the recording again of this to refamiliarize yourself with all the information that's been shared, then you can see the event on our YouTube channel. Just search on the YouTube for Hindu Council Birmingham and subscribe to that, and then you'll be able to see the recording there, and obviously watch it at your leisure and make notes. Jay's details will be there as well. If you need anything else, then by all means reach out to us, Hindu Council of Birmingham, and we'll be more than happy to participate in supporting you in any way we can. We do have a few more events lined up as well. So on the 3rd of February, we've got a session on dementia. Again, that's a very delicate topic that is quite prevalent within all the communities. So we'd like to share some vital information on that. And with that, Vipul, is there anything else you want to add to that before we close down? You're on mute.
I can't think now. I think you said the dementia one. We have got another 2 topics in February, which obviously we'll promote it anyway.
Yeah, information will be shared. If you want any further information, we have a website as well, hcb.org.uk, so please visit that. And we look forward to you participating in our next events. So thank you very much, everybody. Have a pleasant evening, what's left of it, and we will see you soon. Jay, thank you very much again for that.
Thank you, guys.
Okay. Thanks, everybody. Bye for now.